In this video, we are going to talk about top 5 mistakes people make when filing Form I-130 petitions. What is Form I-130? Petition for alien relatives. Form I-130 is petitions from family members of a U.S. citizen or green card holders for getting green cards for their foreign family members. Visit us at Swat&Vee channel with your questions to see how best we can help you out with your process. Please don't forget to subscribe if you're new to the channel. Let's dive in. 1. Designation of where your case will be adjudicated. So on Form I-130, it specifically asks if you're going to adjust your status in the United States or you're going through the consular process and get your immigrant visa at the US Embassy. It's very important to decide which route you're gonna go. If you are in the United States, probably for example, if it's immediate relative petition, do you submit together a Form I-130 and Form I-485? And under these circumstances, you mark yes. We will be adjusting status in the United States and you name the USCIS office where you live. If you are outside of the United States, and you are filing Form I-130 petition, for example, for your parents, for your sister, for your brother, and so on, they will go through the consular processing. Next to it, you would mark the embassy, the country, and the city and province where the US Embassy is located, where you're gonna consular your process. The important thing about it is that you cannot pick and choose the embassy where you're gonna be consular processing. Usually you have to lawfully reside in this country. You might be the citizen of the other country, but for example, you can be a citizen of, I would say, Ghana and live, for example, in Nigeria. So under this condition, you will have your interview in Nigeria because you reside there, but you have to show proof that you are a resident in this country. The mistake most people do is they mark out both adjustment of status in their local field office and the embassy, and USCIS decide this is an adjustment of status case and they keep the case in the US. So now the person will have to go and file Form I-824 and request the case be sent to the embassy, and this is gonna add extra 3 months to a year and a half potentially of delays with Form I-824. This causes extra cost, delays from loved ones. So just mark consular processing if you are outside the United States. Now, there is a vice versa where people mark consular processing and then they come to the United States on a B2, for example, and then they change their mind and decide to stay here. In this method, you will file Form I-485 and it sometimes works out. You don't have to file Form I-824. When it does go wrong, it goes really bad. Side note, if you decide to file for adjustment of status with the National Visa Center, State Department, consular processing, you do want to notify them that you're going to do adjustment of status, because sometimes the Department of State and the NVC will delete a case, or if there is no movement on it after a year. So try to avoid this kind of mess. 2. Separation petition for immediate relatives. So this is really confusing aspect of the Form I-130 process when you're filing for a family member. If you're a US citizen and you file what's called an immediate relative, that's a parent, a spouse, for children, you will need to fill separate Form I-130 for each one of them. So if you want to bring your parents or siblings, for example, you need 2 Form I-130s. One for your parents or sibling, one for the other. If you want to bring your spouse and kids in, and the kids for some reasons don't have citizenship or green card already, you file one for the spouse and then each one separately for the kids, in order to avoid all these extra fees that comes into play. On the other side, if you are a green card holder, you can't file for parents or siblings, but if you file for your spouse, the children automatically comes within it. And when you're a US citizen and you file for your brother or sister, those children automatically come in. The main point I want to make is we have issues where people marry somebody and then they have stepchildren, for example, that are young and they just file one Form I-130 for the spouse, gets approved, and then they are like, well, how come you are not getting consular processing notification for the children? That's because the children don't have a separate petition when they are supposed to, and then you have to wait another 8 to 10 months for the child to get approved, and it's really destructive for the family relationship to be waiting that long. So that's very important for people to know the difference. The reason why they do that is When you're a US citizen and you file for immediate relative, there is no extra waiting line. There is no limitation per year how people could do it. And so that's why they don't have group aspects for this. They say one person at a time to limit the number because there is not that extra way. For example, a spouse of a green card holder may have, but it does pop up where they might have extra year or two because of the backlogs. It gets a little complex. 3. From I-130 documentation. This is very important, not to send your original document with your petition. It's in the instructions, but a lot of people, they don't read the instructions and they send their original. For example, marriage certificate or birth certificate, and that's it. It's gone. When going in for your consular interview for immigrant visa, you will need to bring all of the original documents you submitted to USCIS. But since you have already submitted the original to USCIS and you don't have it on hand, it can become a very big problem during your interview. So please don't submit your original document to USCIS, even though USCIS have a particular form that you can use to request for the original document to be returned. That takes extra work. You don't even know if the original document will be returned or how long it will take, and that might cost you a lot in case you would need it for school records or something. Always remember, it's not a requirement to add your original document to your petition. Always make photocopy of it when filing with USCIS, unless USCIS writes you for the original copy. With this, it's very rare for USCIS to ask for your original document. 4. Domicile requirement. This comes into play on your form I-130, and you always have to be truthful of what your address and residence is with any immigration application. But if you are doing any case in particular through consular processing on a family-based form I-130 petition, the petitioner, whether green card holder or a citizen, has to be quote unquote domiciled in the United States. Now, the domicile requirement was written in an act by Immigration National Act, INA. It's not very descriptive. It's very short paragraph or two on what that means, but essentially they want you to be living in the United States. So let's say I want to apply for my spouse and I'm living in Ghana, for example. They could deny my case later on at the embassy stage, saying I'm not domiciled in the United States. And how they will know that is they will see my address history in the form I-130, and then later on for the applicant support they will see it. So you really want to have your address correct. For example, if you live in the US but you are spending a lot of vacation time with your spouse overseas, keep coming back and forth, that's still vacation. But if you have your house here, potentially work and stuff, you are still considered residing here. So be careful, because if you list on the form I-130 a foreign address but you are not really living abroad later on, they can use it and say, well, domicile requirement shows proof you are actually living in the United States, and that becomes a hurdle. And the regulations for the Domicile Act, they say that even if you are living overseas, you could potentially tell embassy officer that I'm going to move in with my spouse or the family member to the United States upon getting the immigrant visa. That is in the regulations. But just because somebody is in the regulations and the law doesn't mean they are actually going to prove it. In some countries, we'll say it's okay if you're moving with your spouse. It's all good. We will give you the green card. You guys move together. And other countries will say, well, move back to the United States. Show me the lease agreement or home purchase. Show me your work. Show me this and that. And then once I believe you actually move back and domicile in the United States, then I will adjudicate the visa. And all of a sudden, you got to go rent a place, you got to do this and that. So you got to be really mindful about this. Now you have to, again, be honest with it, but you sometimes need to know what's going on and make a decision to stay in the United States so that the domicile requirements won't be a problem later on. 5. Eligible relationship. If you're a US citizen, you can file for your spouse, for your parents, for your brothers and sisters, and for your children, married or unmarried. If you're a lawful permanent resident, you can't file for your brothers and sisters, you can't file for your parents, but you can file for your spouse and minor children unmarried. And you know other children if they are unmarried. So in this case, where the petitioner is a green card holder, files for a single child, and the petitioner is in the process of getting his or her citizenship, gets interview dates in order to become a US citizen, let's say in a week, and the child of the petitioner decides to get married, which the beneficiary did get married with the petitioner is still a green card holder, it will destroy the case because the green card holder can't petition for their married child. Whereas if the beneficiary waits for the petitioner to become a US citizen before getting married, then the process can go through without any delay or denial. Other situations where there is a step-parent relationship, for example, if you're a US citizen and you marry someone's mother or dad, and the child of the person under the age of 18, they come in and could be a step parent and file Form I-130 petitions for them. So that's really important. Sometimes people are deciding to get married, and that's one reason to rush the marriage before the child turns 18. If getting married is in the plans anytime soon in order to get kids in, and there is adoption, whereas adoption has to be completed before age 16, so that's a more nuance. And there is another issue, sometimes you have parents that never got married. The mother could always file Form I-130 for a citizen or green card holder for the child, but there is more stringiness requirements many times for the father if you are not married, if it's out of wedlock marriage. And so for those many times they will say, well, prove to us, even if the parents are not married, that the father was in the child's life. Show receipts of paying school fees, sending money to them. School records are listed as the person comes and pick him up from school or show they are traveling to see the child. Evidence that shows the father is in the child's life to prove that a parent-child relationship exists, even though the parents weren't married, and gets different level of complicity. Many times they don't have documentation. Nowadays with emails and stuff, there are small ways of getting documents, but if you are 1980 to 1990, early 2000s, we don't have as much digital documentation. That makes it much harder to prove this type of relationship existed. So these are some of the mistakes to be mindful about if you're thinking of filing Form I-130. I hope you guys found this video extremely helpful. If you know anybody who could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people will want watching this video. If you like the video, please make sure to hit the thumbs icon. Thanks for watching, and don't forget to subscribe or hit on the notification bell for more immigration updates. Bye!